teaching me about subrogation. So I've been helping my wife with this, with her case. She has a case, or had a case, I should say. And last week, Friday, we sent a letter of subrogation to the judge in her case. And today, Saturday, we got this letter from the attorneys, which I also sent to your email, so you could go look at that. And basically, they're saying to the judge that they want to withdraw their claim because of subrogation. So thank you.
Watch what you say. We're your cod children, we are not children off stale. We can discharge any debt in the public domain. In the debt system we are working in, the most important paw we have is a blue ink pen. With a blue ink pen we can give credit, to any document that does not have a blue ink signature on it. Acceptance is a banker acceptance. You are accepting the document, the presentment, for payment. You are agreeing to pay it. When you pay the document, the negotiable instrument then belong to you. A blue ink pen is a very valuable tool in the world of commerce. Anybody who sends you a bill who does not also send vow a check with which to pay it has created a public liability for which he didn't provide the remedy. Everything in commerce is a mirror image, the exact opposite of real life when somebody sends you a presentment. In the UCC Uniform Commercial Code, in order to create a liability you have to make a presentment and present it to the liablee. In court, the judge will say to the defendant, do you have a copy of the indictment, meaning the information on which the indictment is based, meaning the charge against Io? When you say, no, the judge will say, well, here it is. And if you accept it, if you take it, then you accept the liability of the indictment and you have just voluntarily convicted yourself. Or the judge might say to the defendant, do you understand the charge? If you reply that you understand the charge, you are saying that you stand under the charge, and that you are accepting the liability of the charge. And you have just voluntarily convicted yourself. Some redemptors used to get presentments from the IRS, and the IRS would not send the check with which to pay it. So they would write back to the IRS and say, thank you very much for what you sent me, but you didn't send the check. After a time, the IRS started sending the check, disguised as a payment voucher. IRS presentments usually have a coupon attached at the bottom. That's the check. What you should do: accept it for value and return it to the sender, the IRS, to settle the debt. You don't have to have a coupon attached to do this. When you accept and sign a document, you turn it into currency in the same way a FRN, Federal Reserve note, is currency. Any piece by the faith and confidence of the people can be turned into credit, with which you can make exchanges of value with your credit. The purpose of currency is to enable the exchange, the flow of commercial energy. The presentment has come to the fiction, and you are accepting the presentment and satisfying the liability with your credit for the fiction. The signature on the promissory note creates the money stated on the promissory note that represents your commercial energy. It's the full faith and credit of the people of the United States that gives FRNs the value that they have. Anybody on the street can do this. It is your signature, your credit sign that creates the credit in your name. Endorse it on the back and send it to the IRS, because most of the commercial banks wouldn't know what to do with it. A tax to you is already charged, but a bill is void of charges and has to be charged with your commercial energy before it can be used in our system of commerce. The interest on any endeavor has to be returned to the creator, the principal of the principal account. Hence the popular phrase return to sender. A bill cannot be returned to the principal because it has charge to it. Commercial energy has to be in existence for a commercial charge to move it to ground. A copy of a presentment without a blue ink signature has no value. Charge it to the party that created the bill via the IRS. Once you charge the bill, the interest can be returned via the principal to the creator to extinguish, zero out the account.
And everything is taxes, y'all. Every bill is taxes. And it's supposed to be paid with, instead of debt notes, it's supposed to be paid with the matching interest. And you can accomplish this through the IRS. That's why I keep saying all bills go to the IRS.
1856, the year Texas erased black land ownership records. In 1856, the state of Texas passed a law that effectively erased all records of land ownership by black people. This law, known as the Texas Land Titles Act, was enacted during the Reconstruction era, a time of significant racial tension and violence in the state. The law was designed to undermine the property rights of newly freed.
Look back, when you bought a home, you went to the bank and you filled out some paperwork. And one of the pieces of paper that you signed was your mortgage. And it was notarized and it was recorded with the register of deeds, or clerk of county clerk of court, whatever, okay? And the other piece of paper that you filled out and signed was a promise, and let's say you borrowed $400,000. Well, you signed a piece of paper where you promised to pay that man across the table or his representative $400,000 over a period of 30 years or 20 years or whatever the term was. But you signed that piece of paper and it was not notarized. But it was like signing a blank check. But it was a promise to pay, which made it a negotiable instrument. Now, when you signed that paper, you thought that the bank was going to give you $400,000. That's what you thought. Well, when you signed that piece of paper, what did they give you? They didn't give you anything yet. You just signed the document, and that piece of paper became an asset for that bank. It was now an asset that they owned.
Now, and the funny thing is early on in this matter, I had both the judge and the attorney. They were basically belittling me. Okay, judge would ask me, "Where did you go to school, Mr. Fadjola, for law? Where did you learn law, Mr. Fadjola?" And gee, I'm hitting him with basic things when I'm objecting to this attorney over here, pettifogger shyster attorney, who's got no personal knowledge of any matter. He's letting the guy talk. Sir, objection. He's got no personal knowledge per your own rules, Rule 602. He's not a witness. He can't testify. I'm going to need him put under oath if he's going to testify. And I would get these little responses. Where'd you go to law school, Mr. Fadjola? So, like I said, civil matters turn into criminal matters. So Mr. Judge and Mr. Attorney, now here's the funny thing with Mr. Attorney. Mr. Attorney got yanked off the case about a month ago. His own case. They yanked him off of there. Because I start walking him down this criminal matter road. I said, hey, Mr. Judge, you're an officer of the court. You have a duty and obligation, and when crimes are reported to you, you got to take action, sir. Sir, I'm officially notifying you that this pettifogger shyster attorney has committed crimes against me, and I'm going to need you to do something here, sir, because I need you to stop this guy from committing these crimes. Well, now I put that court in a real awkward position, and that's where they're at right now. And now they're sort of stuck in limbo, and now I'm going to start walking them down the criminal complaint matters, and I'm going to start. I already got them in default. I'm going to start thumping them with commercial liens and with an actual judicial case, a formal case. And he's going to have real trouble coming in and answering that because he's in default on all the affidavits. So I'm going to file against him. I'm going to there's a ton of cause of actions I can bring him in under. And I'm going to attach my unrebutted affidavits to it. And he's got a problem because he had a chance to answer and he didn't answer. So, and you got to remember, listen, this is a thing they've really turned on its head and it got people confused. If somebody's accusing you of something, don't you dare defend yourself by giving excuses, okay? The burden of proof is always on the accuser. You let the
Yeah, you want
accuser
to reassign
make
the
their case.
security
You don't
interest
try and
back to
prove that you're not
yourself.
guilty. That's not your job, okay? Burden of proof always remains on the accuser. Well, that's in a real court of law.
Okay.
That's in an Article 3 court, a court for men and women. Article 1 court, wow, they just flip everything on its head.
Yeah, I
And
would
you're going to learn that
rescind the
Article 1
security
courts, the reason
interest
they have Article 1
or
courts,
just
Article
go ahead
1
and
courts
deposit it to your
run according to
trust.
the rules of civil
If you
procedure.
deal with a
And the
bank,
rules of
hold
civil
on, let me
procedure
turn this
are
down.
rules created by a private legal society, the Bar Association members, that were created to usurp your God given constitutionally protected rights. That's the only reason
Yeah,
that they
let this
have the rules
play
of
and
civil
I'll talk
procedure,
about it.
because it allows attorneys to do things they otherwise can't do, like fabricate liens out of thin air when there was never a trial. There was never a debt that was decided for the lien to be created. So these rules of civil procedure do not apply to you and I, a man or woman. They don't apply to us. Listen, I'm not an attorney. Those rules are written for attorneys. I'm not an attorney. And that's another reason why you stay away from the term pro se. Pro se is a legal term. When they attach a legal term to you, they're diminishing your status down from man down to a pro se. Pro se is basically, think about pro se as being a short-term license to be an attorney. So when they give you that little short-term license, they can now drag you under their rules of civil procedure and violate your constitutionally unalienable rights. And this is all being done in these Article 1 commercial courts. That's the purpose of these rules of civil procedure, okay? That's why they're doing this. I don't take titles. And you say, I'll say I'm not pro se. I'm not an attorney. I'm not a member of the legal society. I'm not representing myself. Think about that word, representing. It means you're representing something else. If you're representing it, you're representing something else. Well, guess what that other thing is that you're representing if you go in as a pro se? You're representing that unlawful illegal trust that they set up under your name. Okay, it's unlawful and it's illegal, and no, your mom didn't sign you away and didn't create that trust. Everything involved with that trust was created by fraud, forgery, and counterfeiting. It's not a lawful trust. Okay, so the burden of proof is always on them. Don't make their case for them. You demand that they make their case. Uh, Now, here's the thing: a lot of things are hidden in plain sight. And we just missed them. And listen, it's not our fault. It's what they've done with school. It's what they've done with the media. It's what our family's done. Things that we were told. We've seen our dad and our grandfather do this, and our mom do this, and we figure, oh, we're supposed to do this. It's all conditioning. It's social conditioning, and they have people believing that the common law doesn't exist anymore. That heard people say, well, we don't do things we don't do things like that anymore. We don't work. We? Who's we? I never signed on to the we. Okay? You guys might not do things anymore like that. Doesn't mean I have to follow you. Okay? And that's a very important part to remember. I'm not anybody's slave. Just because 10 people run over here
commonlawcourts.com.
and they want to do something one way doesn't mean I got to go over there and follow them. That's the power of being in a republic. Okay?
And that's where
Doesn't
y'all
matter. The
cars are
10 have no
supposed
more
to be
rights than I
registered.
do as the one. So don't believe that the common law doesn't exist. Okay, the
It
common law does
exists.
exist. It's not dead. I don't care what they tell you. It's not dead. And I don't care if people saying that. Oh, I went to jail because I use common law. I use commercial law and I beat all my cases. I use common law and I went to jail. Bullshit. Okay, there's more to that those kind of cases that you're hearing about. Common law is not dead. Okay. And if you have any doubt, go read Amendment 7. Unless I missed something that they repealed the Seventh Amendment to the federal Constitution, I'm pretty damn sure that the common law still exists. Uh, it didn't disappear. Okay, that Amendment 7 is there, and we're going to go over Amendment 7 and see just how powerful Amendment 7 is. In suits at common law. Wait a minute, I thought common law disappeared. I thought we weren't doing things at common law anymore. Where the value in controversy shall exceed $20. That's just about everything today. It's more than $20. Traffic tickets, tax bills, whatever. The right to trial by jury, and we're going to discuss this term too. This is another what do they call it? Words of art that they use. The right of trial by jury shall be preserved. That means that they can't take it away from you. Okay? They can't force you into these Article 1 courts. You've got a right to trial by jury. These Article 1 courts are not trial by jury, and we're going to go over that and should prove that they're not trial by jury. And look, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the common law. You know how powerful that statement is? No fact tried by a jury shall be otherwise re-examined in any court of the United States. That means any court that they want you to come into and that you have an ability to appeal the decision, you're not in a common law court. You're not in a court for a man and woman. You're in an Article 1 court. If you're in any court where you can do an appeal, you're in a commercial Article 1 court. You're in their court, okay? You're not in a common law court. So why would you want to do that to yourself? Why would you want to disadvantage yourself like that? And that's what happens when you show up to these courts, in these kangaroo courts of theirs. So we're going to go over the power of this statement too when we get into courts of record. And so think about Amendment 7 has to do with, think about civil law. We're talking about contract law. This is what Amendment 7 has to do with, okay? It's civil law, corporate law.
Okay. Y'all, he's just trying to tell y'all what the difference is between Article 1 and Article 3 courts. All the courts that y'all are going in, chances are they're Article 1 courts, and you're not supposed to be there. But check out commonlawcourt.com. That's actually where you're supposed to register your assets, register your car, and common law court supersedes statutory court. So when you register your cars over there, they supersede anything going on, the fake liens, all of that. So go over there, check out commonlawcourt.com, and yeah, let's get back to the dream work. Okay, so technically all of those processes would work. You could do a 1099-C, you could rescind, what you saying those? Okay, you said it's a business account, it's 2 trucks. Yeah, you could do a 1099-C, you could rescind, or you could just gift the whole account to your trust if you have one. So whichever process you're more familiar with, I would say go with that one. If you did a 1099-C before, do a 1099-C. If you comfortable rescinding the contract, then rescind it. But rescinding the contract, you're going to have to pull the 2 contracts apart, because most contracts are 2 contracts combined in one, where you bought the car, paid for the car, and then they refinanced it. So you got to be able to separate those 2 and go in and rescind just the security interest. So you could do any of those.
Investors that buy the fraudulent note. What's supposed to happen in the mortgage, this is how a true mortgage is supposed to happen. You come to me for a home, I need to put that money in your account. You go pay that home off, now you owe me, right? So you wrote a promissory note with me or a financial statement, and we put it on the public side to let it know I got a lien on you, okay? And it's on, everything's recorded. I'm holding on to it until you pay me back. But this is what the banks do. The banks get you, right at this note, they take that note, they don't even, you don't even want to sign it. They'll take it, flip it over the back, endorse it, pay to the order of. Then, now that's worth $250,000, and they'll tell the investors, okay, this is worth $250,000. Give me $100,000, and you can take the $150,000 over 30 years. Oh, bet that. So I get cash flow. Yep, you get cash flow, 6%, 7% interest. Boom. So they buy it, give the dude $100,000. Now he just got $100,000 off something you signed, and he didn't give you anything. It's a false conception because you got that property, but even on the property, there's a thing called the warranty deed. Typically, the warranty deed say you got the property for $10 from the person who was giving you the home, but the bank's name ain't on there. The bank never has any money to lend. They're lending on false promises and hopes. they got these securities, alleged securities set up for these investors, thinking that they legit when they not legit. So now the homeowner showing up for this home, The bank then already had stuff set up before he came in there. So as soon as they came and signed over them documents, the bank take that document, boom, they go get some money released on the strength of your signature. They got paid multiple times. They got paid with credit and they got paid with a promissory note. They pulled my credit in the beginning. Remember we said that? And they got paid with the application. The application released the funds. Then they got me in the room and I signed over a promissory note. That was a check. Remember when I started, I said these are nothing more than checks. Paid to the order of the sum of, boom, where? They take that to the bank. What did I say they went? They got 10 times the amount of credit. So they got paid again. That's the second time they got paid. Then they left the bank, went to the investors, sold it with a bunch of other promissory notes for the low. Boom, they got paid again. Then the whole time they got you confused, us confused, thinking that we still owe them. So now we signed up for monthly payments. Boom, they're getting paid again. And they never came off anything to begin with. We've already shown you they done got paid 4 times. So once again, who paid? What was free? Only difference was I seen, hold on, man, nah, hell, this shit is bullshit. I don't fucking know you. I proved it, I fucking know you did. Till you can prove it, I'll let you later.
Okay, y'all, I gotta get ready for my next consult. Any more questions before I go? Hello, thank you. Okay, I might be back after I get done. I have 2 more I need to do. Email. My email is on my homepage. Okay.